Today we will be talking about orders of protection, what to know and tips. And with us today, we have Lisa Nolan from Willow and Anne Saleh from Willow as well. And so I'm going to give it to everybody here, to Anne and Lisa to present.
Thank you so much for joining us today. My name is Lisa Nolan. I'm the Director of Prevention Education here at Willow Domestic Violence Center. And this is very exciting for us to be partnering with Resolve today. They're such wonderful partners in doing this work together. So we're happy to be here teaming this one. So today we're going to talk about orders of protection and really all things related to orders of protection. So Anne is our expert in orders of protection, so I'm going to give this over to her in a second. But we also wanted to just make it clear that if you have questions throughout the presentation, to let us know. So put it in the Q&A, put it in the chat. We'll be monitoring both of those things, and we can kind of pause throughout the presentation to answer questions as you have them. We also will have time at the end for questions as you have them as well. So we are so happy to be here talking about this today, and I will give it over to my colleague, Anne.
Hi, Lisa introduced me. My name is Anne, and I am a prevention educator with Lisa, and I also function as a mobile advocate, and I work in court as well. So that's why I'm doing the presentation, because I have assisted clients through that court process, and then also for mobile orders, which we're going to talk about a little bit later. So I am going to go ahead and share my screen now. Really quick. So here's our name and our contact information. I don't know, Lisa, if you want to put any of that in the chat.
I'm just working on it now.
So if there's a way for us to put that in the chat, so that people can see that after I click off this slide. Okay, cool. So our learning objectives for today are to understand some of the types of orders of protection, to understand the process, what it looks like when you go and you apply for an order of protection. Also, I'm going to go over some frequently asked questions that I often hear about from survivors who are coming in to apply for an order. And then we're also going to learn specifically about Willow's court advocacy program, because we do have advocates available to assist any survivors who are interested in going through this process. Now, I know typically you might wait for the end for questions, but if you have a question specific to what I'm talking about, I am going to encourage you to put it in the chat so that Lisa and Carly can observe that. And if it's something we're not going to cover later, well, they're going to go ahead and interrupt me, and I'm going to talk about that specific question as we go. Okay. So I know we're here with Resolve. They're amazing partners in this work. A little bit about us is we used to be known as Alternatives for Battered Women. So anybody who's been in the community for 40 years, we were known by that name. And we changed our name in 2016, really for two reasons. One is that we do serve all genders, and all genders do qualify for orders of protection. So we want to take women out because we have assisted men, trans individuals, all people getting orders of protection. And the other piece is that battered piece, and we're going to go into this a little bit later, but you do not have to have physical violence present to experience domestic violence. And we're going to talk about some of the nuance if you're looking for an order of protection and there hasn't been physical violence present, and how you might qualify for one. We are a licensed provider. We are safe zone trained. That just means that we try and be very welcoming to people from the LGBTQ+ community. And we also have two deaf advocates through Deaf Ignite, who also provide court advocacy in ASL, in American Sign Language, for any deaf or hard of hearing individuals seeking orders of protection. And additionally, we do have advocates in our program that speak Spanish, and we regularly use Language Line. If you are seeking an order of protection and you do not speak English, we will find a way to get a translator present. We regularly work with legal aid to make sure that there are quality translators present if you do have to go into court, and you can get access to those things. This is just a quick overview of some of the services we provide at Willow. The long and short of this slide is I did highlight court advocacy because that's really what we're focusing on today, that program, and our hotline as well. So I'm going to provide the number for our court advocacy program later in this presentation. But if you don't remember our phone number for court advocacy, you can call our hotline or text our hotline or message through our website and let that hotline operator know that you're interested in orders of protection and learning more about court advocacy, and they can send you right along to us.
And I also wanted to jump in on Hotline. So some quick details about our hotline. Our hotline is a 24/7 crisis intervention hotline. So it is a real human every time that phone rings that answers it. It's not an answering service. On the call, on the text, on the real-time chat, on our website, and through Facebook Messenger. It is always a human that's answering that. It is meant for crisis sort of intervention for survivors. So if somebody's happening or they're triggered, that's what it's meant for. However, what we get a lot of is calls from other people. So support people, family, friends, and providers. We get a ton of call from providers. So if you're somebody on this call who is maybe like a social worker or some kind of medical health provider, we get those calls regularly asking us, hey, I'm working with somebody or I know somebody and I'm not quite sure what to do. Can you help me access some resources, or can you just give me some information and some tips on how to best work with and support this person? We do that all the time. So if you have questions, orders of protection related or not, about any of our services or anything DV related in general, the hotline is really the gateway to sort of all of our services and everything we do. So please don't be shy to use that phone number and contact us if you have questions or need something.
Yeah, and we really do get hotline calls from everyone. I also have spent time on the hotline as well as in mobile and court advocacy, and we regularly get client calls from medical providers, other social workers or service providers, sometimes even law enforcement looking to help advocate for survivors. So if that's what you're doing, then that line is definitely open to you. And they can provide some basic information about orders of protection. If you have specific questions, they will refer you to our court advocacy. Other thing to note is that all of our services are completely free and confidential, so there's no charges for the services provided through court advocacy. Legal aid, we're going to talk about a little bit later, some of the details around that depending on your income, there might be a low cost associated with that. Okay, so the first thing we're going to go through is the different types, the basic types of orders. As you're going to learn, these are all kind of adjustable to the needs of the survivor, but these are kind of the main points for each type. Now, there are two types of courts that provide orders of protection or assign order of protection. There is the criminal court, and then there's the family court. Most of today, we're going to talk about family court orders of protection, because that's typically what we in our court advocacy program spend a lot of time supporting survivors with. But I do want to quickly mention criminal orders, just in case anybody on this call does have a criminal order, they want a little more information about that. Criminal orders are issued by a criminal court. So a crime is committed, somebody is like taken away by the police, they're arraigned, and then a judge, without like the input of the survivor, will issue a criminal order of protection. Like I said, I'm not going into details. I actually have had survivors come in applying for family orders of protection and they're not aware of a criminal order. So we've helped survivors get access to their criminal order. There's a lot more flexibility with the family order. And the last piece I want to make is that even if you have a criminal order of protection, if it's not protecting what you want it to, you can go through both processes at the same time. So having a criminal order doesn't mean you can't also file for a family court order as well. Lisa, did you want to add something?
Yeah, I'm just going to jump in there because typically in a criminal court, so like Anne said, a judge will issue an order of protection through criminal court without sort of a survivor's input. So the judge will make all kinds of decisions about contact and stay away and what is included in that order. So if a survivor does receive a criminal order of protection and their kids are not included, because typically they're not, and their pet is not included, because you can include pets in New York State, they can go to family court and petition for those things to be included in a family court order of protection. So you can use both processes at the same time. The survivor has more say in the family process than they do in criminal, which is, it can be a little bit friendlier. Criminal court is still important because that means that something really bad has happened and we need to make sure that something is issued immediately. But the family court is sort of like the safety net if things are not covered that a survivor wants to have covered.
Yeah, and there are things attached to the criminal order, like the survivor might be required to provide testimony through the trial process and everything like that. Now, there are criminal advocates as well through the Victims Advocate Unit, and the Monterey Sheriff has advocates as well, and so does the DA's office. So if you do have a criminal order, we can, if you call our court program, we can talk to you a little bit about that, and then we would provide a referral to one of those programs. Now, as Lisa was saying, you don't have a lot of control over this process. The survivor will have much more control over the family court process. And that's the next 3 types of orders that I'm gonna go through really quickly here. So the first type of order I wanna mention is called a refrain or no offensive contact. So, okay, court jargon 101, a respondent is the person who you are filing against. So the petitioner who comes into court and petitions for an order of protection is the survivor, as we would use the language survivor. So the petitioner comes into court and requests an order of protection from the court, right? The respondent is the person that they are filing against. So the respondent and the survivor can still be around each other, they can still be in the same home, but they're ordered not to commit any family offenses against the survivor. Lisa always calls this the knock it off order, right? It basically means you're in violation if you commit harassment, if you commit a physical altercation, anything like that, financial abuse, that is going to be a violation of that refrain order. Sometimes survivors will come into court asking for a stay away and get assigned a refrain, just so that you're aware of that process. The second type of order from the family court process is that stay away order. This is typically what you might have seen about, like heard about in movies or on television or in the community. This is that 500 feet, right? The respondent must remain 500 feet away from the petitioner at all times. Now, what's interesting to know is that you can include specific addresses on this, specific, like if there is a place of employment, if there is a home that you want to include on this, sometimes a child's school. So in addition to having to remain 500 feet away from the survivor, they will have to remain 500 feet away from that location as well. We're going to go over some of the things you can ask for in these orders, but you can drive the bus as the survivor. You can come into court if you want a refrain or no offensive contact order, you can ask for that. And you can also ask for a stay away order. The last type of order I kind of want to brush on is on behalf of orders. We regularly support survivors who are coming in requesting these. It's what it sounds like. It's the guardian of a minor applying for an on behalf of order for a child, right? So the guardian comes into court, and in this case, the guardian is considered the petitioner, and the child is the minor, and then the respondent would be whoever you are filing against. A couple of points on this one is you have the same opportunity to do the refrain or the stay away. When this happens, the minor or the child will be assigned a law guardian. That law guardian's sole purpose is to maintain the safety of the child and to have the best interest of the child or minor in their mind at all times through the court process. What that means is sometimes it's helpful for the petitioner to apply for their own legal support through this process because they will not be protected by that law guardian. So for example, do we have a question, Carly?
We do. So somebody was curious if minor, is that 16 and younger or 18 and younger?
It's, 18 and younger. Okay. So anybody 18 or older has the right to come in and file on their own behalf for an order of protection. 17 and younger are going to need a parent or guardian present to file for that order. Yeah, thank you. Great question.
We had another question too that you had mentioned it, but I wanted to be clear too. The question is, do you have to specifically request whether you're looking for a refrain or a stay away, or is it determined by the judge? It is both. You can request something specific. So many times with that refrain, or I do like to call it the knock it off order, people aren't looking to leave their relationships at all or yet, and they just want whatever's happening to stop happening. And so that's a really good option to start creating that paper trail and sort of put somebody on notice. So if you wanted to come into court and ask for a refrain, or if you want to come in and ask specifically for a stay away, you can. The judge is going to make that decision either way, but you can be specific in what it is that you'd like to ask for.
The judge in family court will not bump it up for you unless you ask them to. So they will not decide that you need a stay away order in family court. That might happen in criminal court, especially when you're first coming in to request the order. But they may, if you ask for a stay away and they feel like there's not enough evidence to grant the stay away, they may step it down and grant a refrain order instead. Hopefully that's clear. I'm just gonna say this right now, I'm gonna say it throughout. Don't worry about remembering all this information. We regularly answer these questions on the court phone at our advocacy program. And if you have specific questions and we don't get to them here today, just know that that line is always available to you. So those are the main types of orders. Now we're gonna talk about a little bit about the process and what it looks like and how you can be eligible to qualify for one of these orders. So unlike criminal court, in family court, the petitioner initiates the process. So the petitioner, for whatever reason, decides that they want an order of protection, and they come in and they file against the respondent. To be eligible in New York State for an order of protection, the petitioner must be able to demonstrate that a family offense has been committed. And then the respondent who they're filing against needs to be either related by blood, be a current or former intimate partner, or be related by blood or by marriage. So the marriage one gets confusing because we actually had like a mother-in-law come and file against a daughter-in-law. So that is still protected in New York State. It does not have to be like I am married to the person. If you are related to them through marriage and a significant relationship, then the court will allow you to file for an order of protection. I'm not planning today. Oh,
I was just going to say that can include step parents and stepchildren too. This is an important distinction.
Yeah. And I'm not going to go into today what constitutes a family offense because there's a long list and I think that would take the entire presentation, but you can regularly look that up online. It's available on like the justice websites and everything like that, what New York State family offenses are. And you can once again call us and we can walk through the situation and talk you through that process as well. So these are some of the protections that are available. Like we said, you drive the bus on this. You can request a number of protections on your order that are very specific to your needs. And the judge chooses whether or not to grant certain protections. So as Lisa mentioned earlier, like a pet can be included on your order of protection. Emergency custody of a child in common can be included on the order of protection. A vacate order is when you are cohabitating and the vacate will actually, the police will come and remove the respondent from the petitioner's home. So that is an option on an order of protection. And if you are having a vacate and the perpetrator has keys to your apartment, we often do referrals for lock changes at Willow if that's the protection that you're looking for. Also specific requests like return of car keys, return of property if someone has your car, any of those things can be asked for on the order. Things like temporary child support, we will see sometimes on orders. Also removal of guns. One thing we've seen recently is this request for mental health and substance abuse evaluations. So oftentimes survivors will come to us referred through CPS and they will require the respondent to have that mental health evaluation because some of the safety is being impacted by either substance abuse or mental health issues. And all of these can be tailored to your needs. So for example, if there's not emergency custody ordered, and you have to still have contact with the respondent because of, a child in common, then you can be very specific. You can say no third party, no contact, even by third party, except for on Tuesdays at 1 p.m. regarding the exchange of the child, right? And you can also be specific if it's financial reasons you have to have contact, only as pertaining to like the financial considerations around the home. And if you're not comfortable talking to the actual respondent or the abuser, you can request that a third party be assigned. For example, a friend or a family member who would be a safer person for you to contact about those concerns. Lisa, I saw you unmuted. Did you have something to add?
Yeah.
Too?
I was going to add, we can be two things. We can be so specific as to limit the number of contacts too. So, I know that I'm only allowed to contact Anne regarding our child together. So I can, in theory, send you 100 text messages an hour about the child. We can actually talk to a judge about limiting that. Is, you only get so many, or so many in a day, or in a context, or whatever. That can be something that can be requested in order of protection. I also want to just clarify what third party is. Third party is somebody outside the relationship. So if I want somebody else to facilitate the communication, I can say, well, Carly is going to be our third party, and she's going to be the one to pass messages between us. And that's allowing a third party. Restricting a third party from contact is the exact opposite. If I am an accused person, if I am a person who does harm, and I'm trying to get at Anne, I'm going to say, hey, Carly, I'm not allowed to talk to Anne. Can you go and talk to her? Can you message her on Facebook? Or can I use your Facebook to send that kind of stuff? And if that kind of stuff is happening, that ultimately, if we have no third party contact, will ultimately fall back on me as my responsibility to say, hey, friends and family, do not contact Anne on my behalf or anything regarding me, because it will be my responsibility to take care of that and my consequences that come with that. So that third party contact can be really important, because abusers are very crafty about using other people to get at a survivor, or to get information about a survivor.
Yeah, and along with technology, you can include technology. You can include specific things like cannot contact me through social media or technology. If they are posting things about the survivor on technology, the court can order them to take those down and delete any images. Like, so for example, if you had sent an intimate image to during the relationship, like in an intimate relationship, then the court can order that person to delete the image. And they are not, like, that's against the law. They cannot post images, intimate images. You share that, you shared it with that one person at that time. It is not their right to share that anywhere else. So the court can order them to delete those images as well. Yeah. So here's a little bit about, I'm going to walk through the process. So chances are, if you were to call our CAP office, and I was, our Court Advocacy Program office, and I was to answer the phone, I'm going to tell you basically what I would tell a survivor about this process of coming in and filing for an order. So if you would like to file for an order of protection, you can come down to the Hall of Justice at 99 Exchange Boulevard. There is childcare on site. So a child will not, unless it's an on behalf of order, a child will not be allowed to go into court with an adult. But there is childcare on site available through URMC. It's a really, really great, clean, safe childcare right now during COVID. And like, the kids never want to leave. Like, they get toys, like half the time they're leaving with a big old goodie bag from the volunteers that are in there. But you come to 99 Exchange Street, you go up, you're going to go through security. So a little information about COVID right now. You're going to go through your typical COVID screening. You're going to be required to wear a mask. They're going to take your temperature. The deputies will take your temperature. They're going to ask you the questions. Have you traveled? Have you been exposed to COVID? Have anybody told you to quarantine? And then you're going to go through a metal detector to go through security. Now, once you're through that metal detector, there's a bunch of elevators in the middle of Hall of Justice. You're going to take those elevators up to the 3rd floor, and you're going to go to the probation intake window. It's labeled 301A. This is not like typical probation. This is specifically for filing for orders of protection for survivors of domestic violence. So once you go through that process, through that window, they're going to give you like one form to fill out with some basic information. You're going to fill out to the best of your ability all the information that you have, and then they will take your phone number. Now, during typical times, you would go into a room and you would meet with a probation officer, and they would help you write your petition, right? Or the narrative of what happened. Right now, what that looks like is you're going to get a call on the phone, right? So you're going to sit in the Hall of Justice, and you're going to get a call on the phone from probation, and they're going to help you write the narrative of abuse. This is the petition. This is why you're coming in to file for the order of protection. Now, what this looks like is a chronological order of events of the incidences that have happened most recently. You're going to start with the most recent events, and then you're going to move backward in time, and also provide some general information about any concerns you might have. Like if there has been, abuse in the past or throughout the entire relationship, if like the person has access to guns, or if the respondent has access to guns. All those type of questions is when this is what's gonna happen during this process. I'm gonna answer this question later, but I always tell survivors when they call, is sometimes it's helpful to come prepared. So if you know you're coming into court, to sit down with a calendar, or a lot of people have text messages that will remind them what dates certain things happened. So to sit down with a calendar and write out that process for yourself, because it can be very triggering. This is when you're gonna have to relive every single incident of abuse that you have experienced. So coming prepared with a list of dates, knowing exactly what you want to include in that petition can be very empowering for survivors, so that you don't feel so overwhelmed when this process is happening. While you're filling out that paperwork, you'll also get a sheet of paper that asks if you want Willow services and if you want a legal aid referral. So when you click yes on that piece of paper, that's when you're indicating that you want a Willow court advocate to reach out to you. So while you're welcome to call us ahead before coming into court, and we often recommend that survivors do, so we can make plans, a safety plan around transportation or around childcare or any barriers that you might be facing, you don't have to, because you will get that request for service during this process. So once you fill out that, once you talk to probation and you fill out your narrative, then you'll have the opportunity to speak to a Willow advocate. So we do have a private waiting room, especially if, for example, the survivor and the abuser are both coming in the same day to file for an order or for like a court appearance. So we have a private, secure waiting area. And if you're not feeling safe in the Hall of Justice, like in general, then you can call us and we can bring you back to our safe area. A little bit about COVID right now. We are limited in the amount of people we can have in that back office because of COVID, but if that's something that will help the survivor feel safe, we will make a plan to let them have access to that private waiting room even during COVID. So once all of that process is done, you're connected with the Willow advocate, then you will see the judge that day, right? So you go in, we call it the referee, because it's not like an elected judge, but it's still like, they call themselves judge, right? So after your narrative, you're gonna sit in court you're gonna sit and wait a while, depending on how many people are coming in to file for orders, depending on what the docket or the list of clients looks like for the day. It can take several hours, but you will see the judge that day, right? I'm going to go over some recommendations about when to come in a few minutes. But when you go into court, when you go in and see the judge, what's going to happen is they're going to have a copy of your narrative or your petition in front of them. They're going to ask you to testify and tell why you're coming in today to file for an order of protection. You'll have the opportunity to speak. You'll find out right then and there in court if you are granted the order or if you are not granted the order. So it's a very immediate process. You're only in front of the judge for a few minutes. Now, during typical times, a Willow advocate would be able to go in with you to the court and provide that emotional support. We're not legal advice, so we don't speak in court, but we do provide emotional support. But right now they're asking us mostly not to go into court. Once in a while, a judge will call us in if a survivor requests it, but not often. But we have followed, like we follow people right to the court door, and then we'll wait right outside if they need that emotional support piece and welcome them right back out and go over what happened in court with them and do a safety plan specific to that order of protection or whatever happens in court. So regardless of whether you are awarded an order or not awarded an order, or you don't get all the protections that you want, we will tailor a safety plan and resources to what happens in that court. So what happens? You're in court, you get granted that order, what happens next? So we're going to talk about service, but what you know is that you will get handed a packet of paperwork. Inside that packet of paperwork, that service packet, is a copy of your petition. So be aware that that the person you're filing against, the respondent, will be able to read everything that you say in the petition. There will be a copy of your order of protection. There will also be an affidavit of service. We're going to go over service next. But the return date, it's really important. The one thing they're going to hand you to is a card. On that card is the return to court date. Typically, you would have to come into court. Right now, during COVID, they're doing those telephonically. So you'll get a phone call on that date and time, and you need to answer that call. Lisa, we're going to share something?
We have a question. The question
Okay.
is, if you get denied an order of protection, can you apply again? Is there a time frame around coming back to court to petition for an order?
There is no time frame. You can apply for again. Typically, there has to be a new incidence of abuse. If there is no new incidence of abuse, but say you feel like your current petition wasn't exhaustive of everything that you experienced, and if you can add more information, we would recommend connecting with something called an ex parte attorney, which we have connections with at Willow through legal aid. So if you talk to an attorney, the court tends to be more receptive to hearing another petition if there's been a new incident. If you go home and there's a brand new incident, you can come right back in that same day and apply for a new order. But if there hasn't been a new incident, we would recommend meeting with an attorney. And we're going to talk about some of those options a little bit later before you reapply for that order of protection. Yeah. Gonna go on. I'm gonna talk about our CAP services later, but I just want to share a story really quick around COVID before I move on into service. So it can be super, super helpful to call us, because we had a client who called the hotline, really didn't think he was going to be able to make into court. He had 4 kids with him. His abuser had taken all their masks and destroyed them, and hidden the keys to the car, and he didn't have any transportation. By calling our court advocacy program, we were able to make a safety plan with him to get him and his children safely into court, get the children dropped off at daycare, and he was able to apply and get that order of protection. So although this process may seem very overwhelming at this time, and it is a very overwhelming process, I just want you guys to know, and anybody listening, that survivors aren't alone. That's why we're in the court, because while the court might not be completely trauma informed and has a different set of standards that they operate by, we really try and make it as friendly as survivors as we can and advocate for survivors within those settings. So now,
I was just going to answer a couple more questions.
Yes, go ahead.
So another question about petitioning for orders of protection is, how long after an incident do you have to get a petition? For example, if it happened years ago and the person who's moved away, but maybe is now back, can you still petition for an order of protection?
So you have the right, if there has been a family offense committed, you have the right to petition for an order no matter what. But whether or not it's granted can be tricky. And this is actually one of the frequently asked questions I'm going to go over later. So if there's a new incident, so even if it's not the same level of violence, so if there have been physical abuse in the past and then someone comes back and they're contacting you and there may be some abuse through technology or some manipulation going on, you still can apply for that order and include past incidents. But without a new incident, it can be tricky. In that case, once again, we would recommend connecting to an ex parte attorney, or even connecting with one of our mobile advocates. I haven't gone over mobile petitions yet. I'm going to do that in a minute, because if you qualify for our services, then we can help. We have advocates who are trained to help write the petition. Probation does a great job, but they don't have the same time that maybe a Willow advocate would have, and to sit down and really provide the context around why you're applying for the order and going more in depth in your experience and in the survivor experience. So if you're concerned whether your petition rises to the level of being granted an order, then we highly recommend you connect with our services, so that we can either connect you with an attorney or connect you with a mobile advocate to do a mobile petition.
Okay, one more question. What do we suggest if the person who we're filing a petition against is a friend, not a romantic partner, who is the alleged perpetrator? So in New York State, our definition is romantic partners, current or former, or it's people who are related by blood or by marriage. So friends, roommates are not included in that definition of domestic violence here in New York State.
Yeah. I have a follow-up question to that. What if it's someone who is romantically interested in the petitioner or survivor? So they had like expressed romantic interest, but the survivor has declined, and some of the stalking or harassment or abuse is coming in that way.
Great question.
Yeah, that's a good question too. We get these questions a lot, like what if it's my landlord? What if it's my friend? What if the court is going to require that you show evidence of a relationship of some kind? So if it was never reciprocated, it gets tricky. That would be another one of those things where we would recommend, because that kind of starts entering into the legal advice realm. So we would connect you with an so when I say ex parte, sorry, legal jargon, when I say ex parte, that means same day. So we have access to legal aid attorneys that we can connect survivors with on the same day. So rather than me answering that question, if that is going on for someone, we would connect them to that ex parte attorney so they could talk through all of their options. Now, they can decide to press criminal charges and hopefully get a criminal order of protection. So for example, if a roommate stole from them or destroyed their property, or a landlord did something like that, then it becomes a criminal charge. And there's a lot of confusion around that. Like, well, what if I don't have a police report? Or what if I called the police and nothing happened? So there's a lot of gray area there, and you don't have to necessarily report a crime right when it happens. You can follow up, even if it's not safe in the moment when the landlord or friend or person is there to call the police. You can call the police the next day and report the crime, and then attempt to file for and hope to get a criminal order of protection. Hopefully that answers the general question. Yeah, are we good to keep moving? Okay. We're going to talk about service next. So once you've gone through the process, you've gone through court that same day, this is still all on that same day, right? The order is not active until it has been served to the respondent. So even if you've gone through court and you have been awarded that order, you don't have protection until they are aware that they have been served with this order. So there are a couple options for service. I'm going to go over the two most typical and then provide brief information about some others that aren't as strong in court. So the first type that most survivors in our experience decide to go with is called police service. So what this means is when you walk out of court, you're handed that service packet, right? It's got a copy of your petition, a copy of the order of protection, and an affidavit of service on it. That affidavit of service just basically is for the police officer. So you go to the jurisdiction that the respondent is. So for example, if you live in Gates and someone else lives in Webster, then you have to go for police service. You have to go to Webster. You can go to the police department. You can go to a Dunkin' Donuts and call 911, and an officer will meet you, right? So you provide that officer with the service packet and with your contact information and the address where the abuser or the respondent is located, and then they will serve the order. Once the order has been served, the officer will sign that affidavit of service and return it to court, and they will notify the survivor that has been served. The strength of this is that the survivor drives the bus again, right? So the survivor decides if it's not safe right away when they're leaving court to serve the order, then they can choose to go to a safe place or have a plan in place for when they know the order is going to be served, right? The other main type of court is court service. Court service, it's confusing because it is still served by the police, but it's through the court. So instead of you getting a packet in your hands when you leave, the court mails that service packet to the local jurisdiction. So this is really helpful if the respondent or if you fled, so if you fled to Monroe County, or you have your abuser has fled to another state because of criminal charges or anything like that, you can use court service. So the court mails your service packet to the local jurisdiction, even if it's out of state, and then that police department serves the order on that time. You still do have to have an address, and probably some times is helpful of when it would be helpful to serve the order for the police officer. And to check whether it's been served or not, you won't, an officer won't call you. There's a website that you can go to where you can check and see if that order has been served. It's called sheriffassist.org, and you just put in the docket number and the information about your order of protection, and you can check. There's even a notification you can sign up where you get a text notification once your order has been served. So that's just a little bit about service. There are a couple other types. There's an absentee service, where the order just gets mailed to the known address, but that doesn't typically hold up in court because there's no affidavit of service. With both of these types, the officer signs that affidavit of service and turns it into the court. The other third type, which we would have to do a lot of safety planning around, is a third-party service, where a third party, like Lisa was explaining earlier, it could be a family member, it could be a friend, a safe person that is not the petitioner can serve the order and then sign that affidavit of service, have it notarized, and return that to the court as well. Now, the last point I want to make is a lot of times people come into court and they don't necessarily get the order they want. They don't get their children included on the order. They get the refrain instead of the stay away. And they come out of court and they feel like what they've gotten might not keep them safe. So you can choose not to have an order served. You can take that service packet with you. You can try and make a safety plan, but the survivor drives the bus, right? You don't ever have to have that order served. You don't ever, the respondent never has to know that you came into court if that's the safest option for you.
Right. I would just add to that, even if you get everything that you want in an order and everything that you've asked for, we still see a lot of survivors not having their orders served. And that's okay, because the process is overwhelming and it's emotional. And for many people, walking into court is the first step that maybe they've ever taken on their journey as a survivor. So that step alone could be like, you know what? I'm good. I know that I can do it. I've done it. I'm not ready to actually go all the way with this. And that's totally okay. You don't ever have to have it served if you feel like it's not the right time or it might put you in more danger, whatever the reasons. You can come back and request an order of protection again. So just because you have been issued an order and you chose to not have it served this time, if you decide in a few months or a year or whatever to come back and petition for an order again, because now you're feeling a little bit more ready, then you can do that too. There's no amount of time limits that you can come in and do this. It's really on a survivor's timeline, which is really the benefit of family court, is that the person who's petitioning really gets to drive the process here.
And it's the same thing with amending an order or withdrawing an order. A lot of people are afraid to, they might want to withdraw an order. They can withdraw an order. If there's a new family offense, they can go and apply for a new order the next day. You really do drive the family court does. You have much more control than you would in criminal court. So some other considerations about follow-up after service. So once the order is served, it's active. That is a temporary order of protection. So that can be good, and that is good until the next court date, right? So I told you guys about that card you were going to get when you left court that I don't want you to lose, because it's got the date and time of the next court appearance on it. That is the follow-up. That is a follow-up to the initial. So you come away with a temporary order, and you have to show up to the next court date. So right now, I said they're happening telephonically. During typical times, you would need to come into court, although I don't know if they're going to change some of that now that COVID has happened and they're doing so many distance things like over the phone and over Skype. So we give people the number for the court clerk before they even leave the office, because if for any reason your phone number changes, your phone breaks, you have a family emergency and you can't answer the phone, you need to notify the court so that they can reschedule or change your phone number so they're calling that correct number. Because if you're not able to answer the phone or show up for the follow-up court date, your order will be dropped. Now, that first court date, all that's happening really is it gives the respondent an opportunity to respond. So during that follow-up hearing, the petitioner will be on the phone. If either party has legal representation, they'll be on the phone, the judge will be on the phone, and the petitioner and the respondent will be on the phone. You have the opportunity to agree to an order. So if the respondent agrees to the order of protection, then it becomes a permanent order. If the respondent contests the order or says, no, this didn't happen, I do not agree to this order of protection, then there will be more follow-up court appearances. This is where it is really helpful to have legal representation for many survivors and where things can get more difficult. So a lot of people ask me, should I bring evidence with me when I come to court right that day? The answer is no, you don't need any evidence to get a temporary order, but you will have to have evidence in these follow-up appearances. And this is where a lawyer can really be helpful on your behalf. We do regularly provide legal aid referrals, and we have a really close relationship with them through our court advocacy program. And if you don't qualify for free services through legal aid, there's other resources available in the community. And we also have some private attorneys we provide referrals for, so they can support you through that process. Yeah. Here's some frequently asked questions that I just want to go over. Will I qualify for an order if there is no physical abuse, right? I will say that if there has been physical abuse, it is sometimes easier to qualify for an order of protection, but what qualifies you for getting an order of protection is any of those family offenses. So harassment, financial abuse, destruction of property, all of those things, stalking, all of those things can qualify you for an order of protection. Now, a qualifier to that is if you're worried that, like, say your abuser is really crafty and has used all these manipulative pieces to gain control, then it might be helpful to talk to us or an attorney first. A mobile order or we can do mobile orders and mobile petitions. What a mobile petition is when you meet with a Willow advocate who can do the mobile petition, and we talk to you over the phone, and we spend a lot more time than probation does kind of writing out that order. And then what we can do is let the court know that we did the petition. Now, a mobile order of protection is when you have a barrier to getting into court. So for example, if you're under quarantine because of COVID, if you're immunocompromised and you have a lot of concerns, health concerns, and you're afraid going into court could put you at risk for COVID-19, then we can talk to the court based on those barriers, any kind of disability. I actually even had a survivor who the abuser had slashed her tires and she couldn't afford to get them fixed, and the court approved a mobile order for her. So really calling us and finding out more information about whether you would qualify for that order can be really helpful if you do have barriers to coming into court. And then if we can help write the petition, and we can connect you with an attorney, because sometimes when those more manipulative behaviors are in there, an attorney can help advocate for the survivor within the court system and hopefully gain access to that order of protection. I think I already answered the next question. What if I can't come in because of COVID or other challenges? There's definitely options. The court has to approve a mobile order. We can always write a petition and then have that printed out, and you can bring that into court. But to actually qualify for a telephonic or Skype appearance, we need to get permission from the court. So that just means you talk to a mobile advocate, you give us some basic information, we reach out to the court on your behalf to see if you would qualify for a mobile order. If the court approves it, then we go through that process of writing that petition, and the court will reach out to you for your appearance. Another question we often get is, what do I need to bring to court, right? All you really need is your photo ID. And even if you don't have your photo ID, if you have a bill with your name on it, anything, I still recommend coming into court, because we have regularly advocated. So for example, if your abuser has destroyed all of your documentation, then either by connecting you with an attorney or advocating within the court, we can still get you access to and have the ability to fill out your petition and go before a judge. So we strongly recommend you bring a photo ID, but if for some reason you don't have access to it, you can still come into court. And like I said, a lot of survivors find it helpful just to bring some notes with them, because that process can be overwhelming of writing the petition. And the last question, well, there's more questions, but another question I often get, survivors will think they need a police report. And they will come into court like, well, the cops were there, but I didn't get a report, or I didn't call the cops because it wasn't safe. And they don't think they qualify for an order. You don't need a police report. You don't need anything except your narrative and hopefully a photo ID to qualify to be before that judge and write your petition. A couple more questions just around how what the process looks like and how you apply for a violation. So in order to apply for a violation on your order, once again, you don't need that police report. The police don't have to be called. If something happened, you can come into court without involving the police if that's your choice, and apply for that violation. It's kind of a similar process. You will meet with probation, or we can also help you apply for a violation if you have barriers to coming into court. It has to be approved once again by the court. But you just come in and you provide that narrative of what happened, of the new incidents, and they will add that to the order of protection. Sometimes if there's been a violation, so for example, if you've been awarded a refrain and then there's a violation, sometimes they can modify the order to a stay away at that point. The next question is around extending or renewing my order. We get this question a lot, especially around COVID, because they pushed back a lot of court cases and court dates and stuff. So you can apply for an extension, but it's really important that you come in or call us before the permanent order expires. If you call the day after it expires, they won't honor an extension. If there's been a new incident and there's been violations throughout the order of protection, then it's more likely the judge will grant an extension. But once again, if those violations have been more manipulative, have been hard to identify, then it's helpful to talk to an attorney before you do that. And people ask, well, why is it important to do it before? Just because the court tends to respond better to attorneys than they do to say us, because they know how to do it in like the way that empowers the survivor to get access to that extension. Any other questions that you might have? This is our court number right here. Our court advocates are always available. We are running out of time, but I think I have given you quite a bit of information about our CAP program anyway, and that is our number there. And you can definitely call that number with any other questions you have. And court is open during COVID. I don't think I even need to go to the COVID slide because I think I've answered most of those questions as we've gone through.
So, and a question, if you want to just like flip to the how to contact us slide, but a question that's come up is if I have an order of protection from out of state, will New York State uphold that order? And do I need to do anything to register the order of protection from out of state in state?
Yes, so it still is active. So if you move here, so if you're moving from out of state, it is helpful to call the court and have that transferred, or bring a copy with you and have it transferred to New York State, but it's still active. So say you just moved here and you haven't had time. What it does though, to have it transferred, is it makes the process quicker. So when you violate an order that's out of state, then the court has to contact the out of state court, and it can just take some time. Where when you have it transferred, it just can smooth out that process a little bit. But state to state will still honor orders of protection. And the same thing if you have an order of protection in New York and you move to a different state. Yeah. Any other questions?
The question is firearm removal automatically part of all orders of protection? Do I need to request that? Will firearm removal be included even on a refrain order?
Yes, firearm, well, that's a two-part question, but you can, yes, firearm removal will be included on a refrain order. The court will ask you like that, like as much as I said you drive the bus, and that's completely true, that is one thing that the court would like to have happen, to have the firearms removed. And they will ask you, they ask you about that through the entire process, and the judge will ask you that typically during the end of court, like if you're awarded the order, like are there firearms present, and then make a plan with officers to remove them. Yeah.
So the answer to that question is yes, it's part of orders of protection, is to remove those, and you will be asked about it. If there is a specific concern about it, a survivor should obviously become prepared with that information to say, there is firearms, or there are, whatever in the house, and I would like that to be removed. Again, it's going to be included, but it's better to be prepared.
It's better to advocate for yourself. Yeah, always advocate for yourself. Always advocate for what you want in the order. And just one thing about that is we always, not that we recommend legally, but like ask for what you want, ask for more, and then whatever happens in court, that's why our advocates are there, because we can't control anything that happens inside the courtroom, but when a survivor comes out of that courtroom, we can help make a plan. We can help, even if they don't get an order, it can be very helpful to talk about what resources are going to be open to them. because they didn't get the order, or what to do before maybe connecting them with attorney. So if there is a new incident, they already have representation when they're coming back in to file for that order.
Right. So to Anne's point too, if you don't ask for it, nobody knows to give it to you. So, you know, there's no bar in asking for like everything possible. The worst thing that's going to happen is that those things don't happen and you don't have them already. So again, if we don't ask for them, we don't know that they're available and we don't get granted for them. So we say just ask for everything and we'll see what we get. And this is a lot of information for 60 minutes. And you think about the court process, you know, when the survivor comes in, they're in the courtroom for maybe 10 minutes, maybe. It's a very fast process and it's very overwhelming with a lot of information. And that's why it's so important for Willow advocates to be involved and for why we have partners like we do at Resolve who can also help explain the court advocacy process and who can safety plan around everything. So regardless of what kind of order you are granted, if you're granted one, you can talk to a Willow advocate. We can partner with your Resolve counselor and advocates at Resolve to say, okay, this is what we have or don't have. Let's make a safety plan around this. Let's talk about how we're going to be safe when the order gets served. We can talk about how we're going to have our family and our friends be safe as the order gets served or doesn't get served. And let's talk about what the process long-term is. It's not just about we're in court today and then we're in court 3 weeks from now. It is the entire comprehensive process of being a survivor and in living in the situation you're living in. We want to make sure that is when you walk out the door, you have the tools and the skills that you need to be as safe as possible, regardless of what happens in the courtroom. So that's what we're doing, Willow. That's what your, you know, our hosts here at Resolve are doing as well. And we're working together to be able to do this for survivors.
Yeah. And a couple of points I want to make real quick about coming into court. One, we highly recommend you get there either right at 8:30 or right at 1:30 because the process can take several hours. So typically if you get there at 8:30, hopefully the court will see you before it closes for lunch at 12:30. And then the court reopens at 1:30. So if you come in at 1:30, the court will typically see you earlier than before they close at 5. So we do recommend that. And when I say, you know what I didn't mention is when I say permanent order, that doesn't mean permanent like till the end of time. Typically orders last anyway, like around 2 years. Sometimes if it's a very serious situation, I have seen judges award orders up to 5 years, but just so you know, that permanent doesn't mean like that order is in effect for the rest of your life. Yeah. And thank you so much, Resolve, for hosting us, because this is really empowering information for survivors, for other providers, even for law enforcement, anybody who's on the call to have. Because I know you probably have walked through with survivors about how to file for these orders and just how we can all support anybody who's coming into court.
Yeah, we so appreciate you being here today and offering this workshop. I would say like this information was so valuable for me too, as a therapist and counselor working with survivors. It's just so helpful to hear this in such like rich detail. And I know you said this, but I wanted to reaffirm that if people are just curious, because I think this happens a lot, people are sometimes like, you know, I think, but I'm not sure. They can always call Willow and say, so here's what's going on. What do you think? And you guys can be awesome. That's so helpful.
Yeah, we regularly have people calling and asking questions on our court phone, and we welcome it because it really is helpful to connect with us sometimes if you have questions about the process beforehand. Yeah.
All right, well, this was so wonderful. We're so thankful for everyone who attended today. We're recording this workshop, so we're going to post it to the Resolve YouTube page so people can revisit it because our lives are ever changing. So sometimes we need to revisit this really helpful information. And our next workshop will be Monday, April 19th at 12 p.m. for financial independence with financial advisor and Resolve board member, Courtney Laffler. So we hope that you'll all join us then too. So thank you so much, everyone.
Thanks for joining us.
Bye, everyone. Thanks.